the defense attorneys on appropriate questioning of the witnesses, and also during opening statements talk about how upset Mr. Baldwin was, that he was upset, that he was panicked, that he was ashen. He was even ashen in color. What pages 2 through 5 demonstrate, and I want to tell you, let me make one correction.
May I ask something?
Sure.
The highlighted is the portion that you want redacted.
That is correct, Your Honor.
Okay, well, I only see, oh, got the wrong one in front of me. Okay, all right, sorry, I transposed them. Okay, go ahead.
And let me find this part. Hang on just a second.
Thank you.
Okay, so if I to help make my point, if we go down to the last paragraph of page 4, you'll see where Mr. Baldwin is speaking to someone on the phone, and he says, and just spend the time here, and they're going to do what they've got to deal with. He's talking about, I think, investigators and also insurance investigators, and deal with what they've got to deal with. And we shouldn't let, we'll go have, it'll work, and we'll go. And I believe what he says, and I can play it if you need me to, because you can actually hear it on the audio, even though the transcript says indiscernible. We'll go have a good time. So these are not, at this point in time when Mr. Baldwin is making this statement, he's at the police station. He does not know that Ms. Hutchins has passed, but he knows that she's been critically injured, and she's so injured that she's been taken away in a helicopter. And if the defense hasn't spent all of this time saying how panicked and upset he was, I'm not sure that it would be relevant, but he is actually planning basically a vacation, and he tells his family, still come to New Mexico, we'll have a good time. So this is obviously information that directly contradicts what the defense has argued, and if it would help the court to see his demeanor and hear what he actually says, his family was coming to New Mexico the following day because he had a bit part for his daughter in the movie. So his wife and all of his children were coming the following day, and he is telling his, at one point, I think he's speaking to his wife, and he has her on FaceTime so we can actually hear her. We can hear her responses. And then he's speaking to another person who sounds like some sort of a family assistant or a nanny or someone like that. And he is explaining that he wants that person to try to convince his wife to still come to New Mexico because they can't get their money back for the plane tickets, and they'd like to go ahead and have a good time.
Where's the thing about the plane tickets? I didn't read that.
So here's where he says it. There's a part here where he says they're not going to give us our money back.
Oh yeah, that's okay.
That's what he's referring to.
Okay.
So
are you talking about lines 19 through 25 on page 4? You object to the redaction on just this portion?
On what page? I'm sorry.
Well, you said 2 to 5, and then you pointed out a particular portion within 2 to 5.
Overall, my position is this is the defendant's statement, and it comes in, and I don't see a reason that it stays out. And the reason specifically that a lot of this conversation comes in is because of the defense statements about his state of mind, and this directly contradicts those.
Come back up here.
Yes, Your Honor.
No?
Do you want me to step?
Yeah, I want you to go over there.
Can I leave these here?
Mm-hmm.
Okay. I'm just going to set this aside.
So, Your Honor, first, what we have within this section that we're going to be discussing right now is we have also some additional hearsay. So we're looking at not only Mr. Baldwin's statements, but it also includes statements from the female speaker who would be his wife. And then and you see female speaker 1, there's also female speaker 2. So there's additional hearsay aside from, again, the statements that we're talking about with respect to Mr. Baldwin. In addition, when we're looking at whether or not this is admissible, the court has to engage in a balancing test as to what the probative value actually is. The court has already indicated and ruled, in fact, at the motions in limine, that Mr. Baldwin's demeanor, even leading up to the accident, was not going to be coming in because the court engaged in that balancing test and said, for example, anything regarding him exhibiting poor behavior.
Way broad brushing, my rule.
Understood, Your Honor. And so I have actually the court's ruling here, so I'll be more specific. So what it says is that any of the videos or any evidence or pictures which relate to Mr. Baldwin not handling or that goes to the defendant's gun that worked or didn't work, and they're showing that it did work because he's shooting. There's videos showing that he's cocking the gun, and it says that those would come in. However, everything else regarding him yelling at the crew or telling people to hurry up, none of that is relevant, and that is propensity evidence.
Right, and that dealt with what was offered, okay?
That is correct.
Was not offered, this was not even discussed at that time, so this is fresh to the court.
Absolutely, Your Honor. So what we're doing is we're looking at what the court had previously ruled, and then we're using that also to inform the arguments that we're making at this time. And so certainly when we're talking about state of mind for after the fact, that becomes even less relevant than state of mind or actions that were happening leading up to the accident. So when we're looking at what this is actually probative of, the state is saying it's probative of that he's, talking about he's going to go have a good time. He's really not that distraught about it. But if we look again at what is Mr. Baldwin's state of mind after this has happened, what element does that go to within the proof that the state has to demonstrate in order to meet the elements to demonstrate that he is actually guilty of involuntary manslaughter? And the answer is that none of this here is probative of any effect of consequence to any of the elements of the crime that he is charged with. So when the court is engaging in this balancing test, we have to look to see what is the probative value, and there's none or very minimal, but the danger of unfair prejudice is substantial, and it substantially outweighs any probative value in that, again, he's talking about his family, he's talking about plans that they have, and there's danger that the jury will misinterpret that or misuse that to view him as being callous or that he doesn't care about Ms. Hutchins, when actually that's not accurate. So we are asking the court that the court exclude this section that we're referring to. In addition, Your Honor, let me go over to page 5. If the court will look at the top of page 5, here again, this is just more them trying to make him look callous. He's worried about at the top. He's talking about staying away from people.
Look over your shoulder.
Yes, of course. Mm-hmm. Oh, do you want? Okay.
I just want it because mine's under yours, so
Understood.
I can't see where you are. Okay.
So, Your Honor, so what we're talking about here up at the top of the page is, again, he's worried about being photographed. He does live a very public life, and this is a very difficult, sensitive time just in general for everyone. And the references to the media here, again, could be taken as something callous or something of that sort. And so, he's talking about, this is breaking news, this is media, and he's trying to keep his family away from that as well. So it's misleading, and when we engage in a 403 balancing test, this should not come in.
Normally, I would agree, but for the fact that the defense actually made his demeanor after the fact relevant. So now that they've made it relevant, it's relevant, and it goes both ways.
All right, thank you. The court makes the following ruling. Under 11-401, it says it has any tendency to make a fact more or less probable than it would be without the evidence and the factors of consequence in determining the action. It is not only the issue of whether he committed the crime of involuntary manslaughter, it's also a relevant fact, and you all made that fact very important through Officer LaFleur yesterday. So I do find that it's relevant to basically respond to you all talking about how upset Mr. Baldwin was, and certainly that you considered that fact of consequence, and I'm deciding that this rebuttal information is of consequence. I also find that its probative value is not substantially outweighed by the danger of unfair prejudice and all the other choices that are under 11403. I will say that I think that I'm not going to let everything in. I'm going to focus on page 4, and I'll start with line 16 and on page 4, and I will go to page 5.
And I'm sorry, is this what's coming in or what's staying out?
No, it's coming in. The rest of the yellow is staying out.
Can you repeat that line
Just
again?
a minute, I'm reading page 5.
Okay, sorry.
Okay, so it's line 16, starting with Alec Baldwin, finishes the rest of the page 4, starts on page 5 at the top, and finishes on line 10. The rest of the yellow will be redacted.
Understood.